On November 7, 2025, the Supreme Court issued a stunning and unexpected temporary stay, granting the Trump administration the authority to halt billions of dollars in food assistance programs across the country. This decision sent shockwaves through communities nationwide, as it meant that critical support for millions of Americans could be suspended almost overnight. With the stroke of a pen, 42 million Americans, many of them children, seniors, and working families, were suddenly plunged into a state of deep uncertainty about how they would put food on the table in the coming days and weeks. The decision, delivered by Justice Ketanji Brown Jackson, did not resolve the underlying legal dispute over the funding of food assistance. Instead, it froze the distribution of aid, leaving families, advocates, and local officials in a state of limbo, unsure of what would happen next or how long the uncertainty would last. SNAP, the Supplemental Nutrition Assistance Program, is the nation's largest and most vital anti-hunger initiative. Overnight, it became a political pawn, as the Supreme Court's move transformed a complex legal battle in Washington into a very real kitchen table crisis for families across America. For many, the prospect of losing SNAP benefits meant skipping meals, rationing groceries, or turning to food banks already stretched thin. The Trump administration defended its actions by arguing that it could not legally spend funds that Congress had not appropriated, framing the issue as a matter of fiscal responsibility. However, advocates for the poor and hungry accused the administration of weaponizing a budget impasse, using bureaucratic maneuvering to cut off essential lifelines for the most vulnerable Americans. As the weekend began, millions of families faced the grim reality of empty pantries and anxious waiting. Lines at food banks grew longer, and uncertainty hung in the air. Their fate now depended on the next move in a high-stakes legal chess match, one that would determine not just the outcome of a court case, but the daily survival of millions of Americans. This crisis began with a 38-day government shutdown after Congress failed to pass a 2026 budget, cutting off funding for key programs like SNAP. SNAP's reliance on annual appropriations made it especially vulnerable. For the first time in its history, funding was completely suspended. The program, serving children, seniors, and low-wage workers, provides essential food aid, $298 a month for a single person, totaling nearly $9 billion monthly. The USDA's October announcement to suspend November benefits turned a budget dispute into a humanitarian emergency. The shutdown exposed how political gridlock can devastate millions, transforming a procedural failure into a national crisis. The courts were forced to step in as the social safety net unraveled before the nation's eyes. During a period of intense political gridlock, the Trump administration, represented by Solicitor General D. John Sauer, took a firm stance regarding the Supplemental Nutrition Assistance Program, or SNAP. The administration argued that, under the Constitution, it was strictly prohibited from releasing SNAP funds without direct and explicit approval from Congress. This position was not just a technicality, it was presented as a fundamental principle of American governance, rooted in the separation of powers doctrine. According to Sauer and his team, any attempt to distribute funds without congressional appropriation would undermine the very framework of checks and balances that defines the federal government. The administration's legal team insisted that obeying a lower court's order to pay out SNAP benefits would not only violate the separation of powers, but also set a precedent that could erode congressional authority over federal spending. They warned that if the executive branch could be compelled by the courts to spend money not appropriated by Congress, it would fundamentally alter the balance of power between the branches of government, potentially opening the door to future abuses. However, this argument was met with fierce opposition from critics, advocacy groups, and many lawmakers. They contended that the administration was using the ongoing budget impasse as an opportunity to advance its long-standing goal of reducing the size and scope of social welfare programs. For many, the refusal to release SNAP funds was seen not as a principled stand on constitutional law, but as a calculated move to shrink the social safety net, even at the expense of millions of vulnerable Americans. In federal court, Judge John J. McConnell Jr. and the plaintiffs pushed back, arguing that the executive branch not only had the authority but also the moral and legal duty to ensure SNAP benefits continued. They pointed to existing mechanisms within the law that could be used to prevent a lapse in funding, emphasizing the real-world consequences for families who depended on this assistance to put food on the table. The Trump administration's appeals framed the dispute as nothing less than a constitutional crisis, Officials warned that if courts could force the executive to spend money not appropriated by Congress, it would create fiscal chaos and undermine the nation's budgetary process. They argued that such a move would blur the lines between the branches of government, making it difficult to maintain fiscal discipline and accountability. Yet, years of attempts by the administration to restrict or cut SNAP benefits had already fueled deep suspicions among the public and advocacy groups. Many believed that the funding halt was less about constitutional principles and more about advancing a political agenda aimed at reducing government assistance for those in need. Ultimately, the legal battle over SNAP funding became a high-stakes test of whether constitutional arguments and procedural debates could take precedence over the immediate pressing needs of millions of Americans facing hunger. The outcome would not only affect the future of SNAP, but also set a precedent for how the government responds to crises that pit legal theory against human necessity. In a dramatic and unprecedented move, Judge John J. McConnell Jr. issued a direct order compelling the administration to immediately fund and distribute November SNAP benefits. This bold action came as a sharp rebuke to the government's ongoing inaction, which had left millions of vulnerable Americans in limbo. Judge McConnell's decision was not just a legal maneuver, it was a statement about the urgent need to protect the nation's most basic social safety net, especially during a time of political gridlock and uncertainty. In his ruling, Judge McConnell made it clear that the executive branch's statutory duty to administer SNAP could not be set aside simply because of a budget impasse. He sided with advocates and legal experts who argued that the administration still had options to ensure families would not go hungry. The judge's order underscored the principle that the law's intent to provide food assistance to those in need must be honored, regardless of political stalemates or fiscal disputes. For the 42 million Americans who rely on SNAP, Judge McConnell's order was nothing short of a lifeline. It briefly restored hope to families facing empty cupboards and uncertainty about their next meal. The decision also reaffirmed the vital role of the judiciary as a check on executive power, demonstrating that the courts can intervene to protect citizens' rights when other branches of government fail to act. However, the administration responded almost immediately, filing an appeal and arguing that Judge McConnell's order overstepped constitutional boundaries. Officials claimed that the judiciary was interfering with executive authority and the separation of powers, setting the stage for a high-stakes legal showdown. The legal battle quickly escalated, with McConnell's ruling serving as the opening shot in what would become a rapid and contentious series of appeals. Both sides prepared for a fight that could have far-reaching consequences for the future of federal assistance programs and the balance of power between the branches of government. As the fate of SNAP hung in the balance, the nation watched anxiously. The next round of court decisions would determine not only whether millions would continue to receive food assistance, but also how far the courts could go in compelling the government to fulfill its obligations to the people. After Judge McConnell's order, states like New York and Pennsylvania rushed to issue November SNAP benefits, offering brief relief to millions. The Trump administration quickly sought an emergency stay, first from the First Circuit, then the Supreme Court. Justice Ketanji Brown Jackson's late-night stay froze the process, plunging states and recipients back into confusion. Some families received benefits, others did not, as state agencies scrambled to interpret shifting legal orders. The legal whiplash turned a lifeline into a source of anxiety, with millions caught in the crossfire. As the weekend unfolded, the Supreme Court's next move would determine whether aid would flow or remain frozen. Behind the legal drama, 42 million Americans faced a stark reality. Without SNAP, hunger loomed. Parents skipped meals for their children, seniors chose between food and medicine, and food pantries were overwhelmed. The crisis exposed the fragility of the safety net. Never before had SNAP funding lapsed nationwide. Charities struggled to fill the gap, but the scale was unprecedented. The psychological toll, stress, anxiety, and loss of dignity was immense, compounding the material hardship. The ripple effects threatened public health, child development, and local economies as billions in aid vanished overnight. Warren Buffett would likely call the SNAP crisis a self-inflicted wound, bad business, and worse ethics. He'd argue that feeding citizens is a productive investment and letting political squabbles threaten basic needs is folly. In a nation as wealthy as the U.S., he'd see the failure to fund SNAP as a matter of misplaced priorities, not resources. Buffett's belief in fairness would frame SNAP as a tool for equal opportunity, not a handout. He'd urge Congress to do its job, likening the dysfunction to a company whose managers argue instead of working. For Buffett, the answer is simple: stop the games and feed the people. It's just common sense. As of November 10, 2025, the SNAP crisis remains unresolved, with the Supreme Court and Justice Jackson at the center. The next decision could empower the executive to suspend aid in future disputes, or strengthen judicial oversight. Either way, the precedent will be profound. For millions, the delay has already caused harm, eroding trust in government and deepening hardship. The longer the standoff continues, the greater the damage to families and the nation's social contract. Ultimately, only Congress can end the crisis by passing a budget and restoring stability. Until then, the country waits, as the courts weigh not just law, but the very meaning of justice and compassion.